Hello and welcome to the Settlement Channel. I'm Vanessa Pang. Today we'll go over pooled special needs trusts, what they are, and why an S&T might be the best option for you. Jennifer Lile, a director with Krugliak, Wilkins, Griffiths, and Dougherty Company in Canton, Ohio, is joining us on the phone. She's a member of the Special Needs Alliance, a national organization comprised of attorneys committed to helping individuals with disabilities, their families, and the professionals who serve them. Jennifer, let's start off by talking about what a pooled special needs trust is.
A pooled special needs trust is a type of trust that is exempt for purposes of both Medicaid and Supplemental Security Income, or SSI, eligibility purposes. And this is all related to 42 U.S.C. Section 1396P D4C. And I mention that because many practitioners, many family members refer to these types of trusts as D4C, and that's where that language comes from. Under the Social Security POMS, or Program Operations Manual system, this is one of several types of trusts that are not counted as a resource, and that's all based on the federal statute. One item that's worth noting here at the beginning is that when a person considers using a D4C pooled trust as an option, they are not typically equipped to receive non-cash assets such as real estate or non-publicly traded stocks. There are two basic types of D4C trusts, first party and third party. First party are funded by the disabled individual himself or herself, or they are funded with the assets that belong to that disabled individual, such as the proceeds from a personal injury settlement, an inheritance they may receive, sometimes from back payments of Social Security benefits. Such a trust may be established by the beneficiary himself or herself. In some states, they may also be established by the agent of the beneficiary under a power of attorney, which authorizes the creation of trusts. They can also be established by the beneficiary's parent, grandparent, guardian, or court. Now, a third-party pooled trust is kind of an oddity in that technically a third-party D4C trust is one that is funded by someone else other than the disabled beneficiary with assets that never belonged to the disabled individual. And therefore, it's odd to use those funds to fund a D4C trust because these trusts have a mandatory payback requirement, meaning that upon the death of the beneficiary, any funds remaining are subject to being retained by the nonprofit administrator or being reimbursed to the state or states for the total amount of the medical assistance paid during that beneficiary's life under the state plan. So typically, a third-party D4C trust is not used because a third party could establish simply a wholly discretionary trust that is not a countable resource at all. It doesn't fall under these exempt types of trusts and would not have a mandatory payback provision.
So, Jennifer, is there an age requirement that we should know about?
With D4C trusts, they can be established for any beneficiary who is under the age of 65. In about 20 states, a person of any age may establish a D4C pooled trust account. However, there are still some states which penalize individuals who are over the age of 65 for the transfer of assets to a D4C trust, and this is a matter of ongoing litigation in those states that don't specifically authorize the creation of D4C trusts for individuals over 65 yet.
Okay, can you touch on how to handle funds upon the death of a beneficiary then?
Sure. So upon the death of the beneficiary, funds that are still in a D4C pooled trust have to be administered in a very specific way. And again, this is all dictated by the Social Security POMS. They are subject to basically one of two options initially. They may either be distributed to a specifically authorized nonprofit entity. Typically, this would be the actual nonprofit that administers that pooled trust. So the pooled trust company that the family works with, for example, has to be a nonprofit, and one of the options that can happen to any remaining funds would be that they just are retained by that nonprofit. The second basic option is that they are to be paid back to the state or states if the person lived in multiple states and received Medicaid in multiple states, So paid back to the state to reimburse the state, or if there's multiple states, ratably to reimburse the state for benefits they have paid out over the course of the life of that beneficiary. Now, this raises sort of a strategic point, and that is that in general, when you establish a D4C trust, the intention should be to aim to use those funds, not to let them sit there and accumulate until the death of the beneficiary, but rather to use them in ways that will improve and magnify the quality of life of that individual. There are certain plans, certain pooled trust companies, which will allow you to also name remainder beneficiaries, such that if there were significant funds in the pooled account, for example, and maybe the Medicaid claim was very minor, very modest, then after repayment or reimbursement to Medicaid, some pooled trust companies will allow individuals such as family members to be named as the remainder beneficiaries. So that's something to check when you establish a pooled account. I would note that there are a few things that can be paid prior to reimbursement to the state, certain taxes, reasonable administrative fees that are involved in wrapping up the trust. There might be an accounting fee or some court costs, things of that nature. But specifically, no other debts or funeral expenses can be paid after death. And so you definitely want to take care of expenses such as prepaid funeral arrangements during the beneficiary's life to avoid any problem after death in using those funds.
So why should someone consider a pooled special needs trust?
There are quite a few reasons to consider a pooled trust as at least part of a plan, if not the full plan for excess monies. Remember that for Medicaid and Social Security or Supplemental Security income purposes, an individual may only retain $2,000 of their own. And so there's a very low threshold for resources when it comes to eligibility. Some of the reasons to consider a pooled trust versus other options include long-term access to a professional trustee. These trusts have to be administered by a qualified nonprofit which partners with a financial institution, and that financial institution actually serves as a professional trustee. Beneficiaries reap the advantages of having professional management without bearing the full cost of traditional professional trustee fees. So if you or I were to go and simply try to have a bank serve as trustee of a trust of ours, they would be charging a set fee schedule, whereas with these pooled trusts, typically those fees are very minimal. Most of the time, a beneficiary will see a much greater return on the investments because they are invested as a pool. You get that greater volume or buying power with the investing. And often also ancillary services like tax preparation are included in the administrative costs, and really each beneficiary is just bearing a fraction of that cost. Another reason that it's worthwhile to consider a pooled trust is that the balance or the amount of funds coming in may really be too small for a typical financial institution or professional trustee to handle. This has become an increasing problem over the years with trusts in general, setting aside special needs trusts, because many corporate trustees have high minimum trust balance limits. These balance limits might start at $500,000, $1 million, maybe $2 million. But with pooled trusts, D4C pooled trusts, the beginning balance is often permitted to be very modest, even just a starting balance of $5,000. And these trusts can even continue to be part of the pool after they dip below that amount. So you certainly get an advantage in that way. Certain states allow these to be dry trusts as well. In other words, you can do the paperwork to have the trust be in place in the future, or the trust account be in place in the future, and not have those funded until the death of a parent, for example, if they're using that as part of their plan. So if it's too small to handle otherwise, a pooled trust is often a really good alternative. Another reason is that pooled trusts are less expensive to create and administer for the most part. While there are costs involved with D4C pooled trusts, they can be less expensive than the typical other alternatives, such as creating a private, what we would call D4A trust, under the same code section, 42 U.S.C. 1396 PD4A. That type of trust and many other kinds of trusts are trusts that a private attorney creates. They are administered privately by perhaps family members or friends of the beneficiary, but it involves the actual creation of a trust agreement, ancillary documents that go along with that. And so this approach usually results in greater attorney fees, legal fees, when there's a custom drafted trust. With a pooled trust, the setup fees charged by the nonprofit are often in the range of $1,000 or so, and the ongoing administrative expenses typically have a modest annual fee of around several $100s. The bank or the financial institution that serves as the third-party administrator with the investment authority is also sometimes charging a fee, but that's often very low as well, 1% to 2%, for example. So overall, comparing apples to apples, a pooled trust is often going to cost less. Another reason to consider a pooled trust is that nonprofit administrators are experienced special needs planners. And so one of the most significant advantages of using a pooled trust is the expertise of the administrators, in that they're charged with staying abreast of the constantly changing world of public benefits. It is very difficult for family member trustees to know and understand all of the basic fiduciary responsibilities of a trustee, such as prudent investment, fulfilling the duties of loyalty and impartiality, all of those basic trustee duties, let alone staying current on what a special needs trust may or may not be used for. This changes over time. We've seen it change recently as far as what a special needs trust can or cannot be used for. And so having a professional administrator is a fantastic tool for family members. In addition, the way that a special needs trust is administered may actually change depending on the types of benefits that a particular beneficiary may be eligible for at any specific time. For example, a beneficiary might be eligible for SSI during one period of time in their life, but then may become eligible for SSDI in the future, may be eligible for Medicare, may be eligible for Medicaid. And so these different programs, which have different requirements, can result in different ways that the trust will be administered as it moves forward. This is a complicated area of the law, and if a trust is not administered properly, there can be very devastating results. Losing medical coverage can be extremely devastating for special needs beneficiary. One more reason to consider a pooled trust in one's planning is that a beneficiary may benefit from a much wider array of investment options. These trusts can facilitate more diversification and reduction of general market risk. Having the advantage of a trust being managed in a pool for investment purposes, the options are much broader in terms of diversification and reducing market risk. So you have a very limited pot of funds, $5,000. How much can you really diversify that? Whereas if you have $5,000 in a pool of millions of dollars, you get a much broader array of what that can be invested in as part of the pool. I can personally say that during the 2008-2009 time span, I'm not aware of any of my clients who had D4C pooled trusts at that time who experienced a significant loss in their accounts. And I would attribute that to the prudent investing and strategic diversification of the professional trustees in those cases. They know that they have many small accounts to administer, so they are very prudent and careful in how they're invested, and yet they do that in a way that covers a broad spectrum of types of investments.
If someone is thinking about investing in a pooled trust, what are some considerations?
There are a number of factors to consider when you're choosing which pooled trust to use. It is interesting to see how different ones operate differently, even within the same state, for example. Some of the things to consider are, what services exactly do they provide? What are the costs involved? What are their distribution policies? How do they operate that? Do they have a designated person? Some institutions call them a designated advocate or an agent for that beneficiary, or can the beneficiary, if he or she is able, talk directly to the administrator of the pooled account? What are their investment policies and what financial organizations do they work with? For example, some pooled trust companies offer the option of investing funds into an annuity product, and some of those annuities are guaranteed annuities for the life of the beneficiary. So even if their own monies that they put in would have been exhausted over time, they can use those instead to purchase a guaranteed life annuity. Another item to consider is how much detail will be included in the reports that are sent to the beneficiary or to the family member who's helping the beneficiary. And you want to know how often will those reports be issued. As with most banks that handle trusts, you would expect them to be sent at least on a quarterly basis, if not a monthly basis. You would want to see a breakdown of what the growth in the account was, what the expenditures were, what the current balance is, because one of the requirements of a D4C trust is that the administrator must keep separate accounts in terms of reports and accounting for each beneficiary. As with many other things in life, it's always a good idea to seek the recommendations from other family members or other families who have special needs beneficiaries. And you are also in good stead to ask special needs trust attorneys in the area. They will no doubt have experience with working with pooled trust companies because it's just such a useful tool for many families. I would encourage anybody who has questions about what pooled trust companies are operating in their area or their state to look on the Special Needs Alliance website. That's specialneedsalliance.org. And if they click on the useful links, they can search for pooled trust directory by state, and there's just a map of the United States, and you click on the state that you're interested in, and you can see links to each of the companies that administer the pooled trusts in that state.
Jennifer, thank you so much for joining us today.
Thank you very much.
And you've been watching the Settlement Channel.